The Court of Justice of the European Union has recently ruled that in a redundancy situation, an employer cannot assess workers who have been absent from work due to parental leave on different criteria to those at work for that period. The court found that EU law precludes the assessment of absent workers on less favourable criteria to that applied to workers not on parental leave. Therefore, the assessment must encompass all potentially affected employees, and all potentially affected employees must be subjected to the same criteria regardless of whether or not they are on parental leave. Therefore, the fact that a worker is or is not in work should not have any bearing on the criteria applied. The court also found that the dismissal of a female worker who had been transferred to another post upon her return from parental leave on the basis of different criteria to that applied to those in her work, where it was still possible for her to return to her previous role or do work of a similar nature to her previous post, was unlawful because at the time of the transfer the employer knew that the new post was soon to be abolished. For advice on any employment-related matter, please contact our employment team.